Where am I looking for the light?
The light's
Oh, that light there, okay, thank you.
Mm-hmm.
I'd like to call the Planning Commission meeting for Monday, October 10th, 2022 in session. Iris or Christina, would you like to call the roll, please?
Heap,
Here.
Leek,
Here.
Mitchell,
Here.
Phillips, Rigby,
Here.
Stewart,
Here.
Vance, and then Moreno is excused tonight.
Thank you. Do we have a council update this evening? I don't see Councillor Mance, so I guess we will not have one. Is there anyone who would like to make a public comment before we proceed with our agenda? Thank you. Can you state your name and what organization you're representing, or just if you're representing yourself?
Good evening. I'm Carol Okert, and I'm representing Fan Forest Hills Neighborhood Association. I'm hoping that as members of the Commission for Citizen Involvement, you will be interested in hearing a little bit about what positive things can and have happened when residents participate in pre-application conferences. Another board member and I attend pre-apps on behalf of Fan Forest Hills. Here's the basics. I am notified by email that there will be a pre-app at an already scheduled date and time. Along with that notice, I am emailed a copy of the request for pre-app sheet the applicant has submitted to the city, usually along with a rough sketch of the applicant's ideas for the site. At that point, I can choose to send in written comments to staff, and I make a note to attend the pre-app that usually happens about 10 days after the notice. It's my responsibility to notify the other Fan Forest Hills representative. The meetings are now held either in person at City Hall, on Zoom, or hybrid, and staff is very accommodating in working out those details. The applicant often has a team attending. It is very clear that the pre-app is for the benefit of the applicant. They are paying for it. They need good information. Often, the applicant does not own the site, and they are trying to assess the situation. On the morning of the meeting, staff sends out written notes that cite relevant code. During the meeting, staff walks the applicant through the notes along with good interactive discussion. And then the neighborhood reps are asked if they have any comments. Code can be complex. In Fan Forest Hills, we have the added element of a DRD overlay on certain streets. There have been times when we as neighborhood reps who are very familiar with our neighborhood code have needed to prompt staff to reassess the code notes because there has been some confusion. And again, we all want to be sure the applicant is getting accurate information. These moments are elucidating and supportive. Staff will fact check and do follow-up emails. We are in that pre-app meeting working together so that the applicant is well informed. Two other types of opportunities happen in our pre-apps. Recently, a potential buyer of an older home was looking at remodel ideas during the pre-app process. We were able to tell the applicant about the past history of the home, who had built it, about the success of remodels that had happened over time. We were also able to connect the applicant with a neighbor who had photos, both inside and outside of the home, that might be of help. We were able to tell them a fun story about a hidden room that had originally been used to store valuables many, many years ago. As neighborhood reps, we are a touch point to the neighborhood, and we invited the applicant, as always, to our monthly board meetings. One other exciting story currently underway: a developer came to a pre-app with the idea of building 2 rows of 3-story townhomes facing each other across a drive strip. As residents of the neighborhood, we knew the site well. We could see that this plan underutilized the site and did not capture the views of Mount Hood. We also knew of another development of 3-story townhomes in the neighborhood that had been extremely difficult to sell. We told the applicant about the demographics of our neighborhood. Retirees are looking for building security and tend to balk at so many flights of stairs. I had an architectural illustration that had been done for a larger parcel in that location that I shared with the applicant's team. They rethought their concept and began working intensively with myself and Jim Ballin to design an amazing project that is now being built. 15 secure, single-level condos with beautiful decks and sweeping views of Mount Hood, an asset to the neighborhood and the city. These are true stories of how neighborhood reps volunteer their time and expertise to bring great value to Lake Oswego. Honestly, it isn't all about, is it clear and objective, or tussling over variances. There is so much more to the story of how we keep our community vital, connected, and vibrant. And as the Commission for Citizen Involvement, I hope you find this 5-minute description of how neighborhood participation brings value to pre-application conferences, and I hope you'll pass it along to the Planning Commission. Thank you very much.
Thank you. Can I ask a question?
Certainly.
Are you in favor of a mandatory pre-application conference
For,
for a builder or a homeowner to develop a property?
I am not here to suggest that that's something that should be done for every property in the city, but I do think it's a good idea when there are properties that are going into a development situation where we absolutely can be helpful. So I would like to advocate that in those circumstances and at times when you might be reviewing that you would keep this in mind. We really do want to be helpful in those situations. So even if, and for example, an example might be the current situation with pre-apps that are for ADUs, and there is very little flexibility, as you've heard already in annual code updates. You've been hearing about that with ADUs. Still, we go to a pre-app for an ADU, and we can indeed be helpful. We have a conversation that sometimes talks about, is there a tree that's going to come out? How might the neighborhood feel about that? What about the neighbors on either side? And so in a situation like that, even though there isn't a wide range of things in the sense of variances, we really do try to be helpful and do our best to get a good outcome for everybody involved. And again, keeping in mind, we know we're there to try to help put together the best package possible for that site.
Thank you. Commissioners, any other questions for Ms. Okert?
Thanks for your time. Really appreciate it.
Thank you. We have one somewhere here. We have one announcement for general update for citizens' involvement. The Waluga Neighborhood Association will have their annual general meeting on Wednesday, October 19th, from 7 till 8:30 p.m. at Our Savior's Lutheran Church, 15751 Quarry Road, Lake Oswego. And they will elect board members and learn about the elephant stele moving into Waluga and what safe routes to school will mean for the Lake Grove Elementary School and a few other topics. So if you are in that neighborhood, please plan on going to that meeting. Now we're going to approve the minutes from September 26, 2022. Do I have anyone who would like to make additions or corrections to those minutes? Seeing none, I will ask for a vote to approve the minutes.
Motion to approve.
Second.
Thank you. Roll call?
Heap,
Yes.
Leek,
Yes.
Mitchell,
Yes.
Phillips. Phillips,
Here. Yeah, sure. Yeah, yes.
Rigby,
Can't hear you.
Rigby,
He said yes, but he doesn't have any sound, it seems.
and Stewart.
Yes.
Thank you. We will next proceed to our public hearing, which is the Community Development Code amendments establishing mitigation requirements for Ministerial Residential Development, LU 22-0031. And we will accept public testimony, but before we do that, would Mr. Boone explain to us where we're going with this evening and the parameters that you're,
Be happy to, Chair.
thank you.
And I think I can incorporate that with the hearing process. So I'm going to read the standard hearing process and then respond to a question you asked me to.
Thank you.
This is a legislative decision, which is generally a policy decision within the discretion of the City Council. The Planning Commission will review the legislative proposal and make a recommendation to the City Council. Although a legislative decision may be discretionary, it must also comply with any applicable, as well as any applicable statewide planning goal or administrative rule adopted pursuant to ORS Chapter 197. A legislative amendment to the Community Development Code must also comply with any applicable provisions to the Lake Oswego Comprehensive Plan. The public hearing process will begin with a presentation by staff, then testimony will be received from the public. Individuals will be allowed up to 5 minutes. Recognized neighborhood associations, homeowner associations, government or government agencies, or other incorporated public interest organizations will be allowed up to 10 minutes. The time limits will not include time taken by questions from the commission or responses to such questions. Testimony by attorneys, representatives, and witnesses on behalf of or which are part of the presentation by a person shall be counted within that person's time limit. Any person in attendance may cede his or her time for testimony to another person, but in no case shall any person's testimony be increased to greater than 10 minutes. At this point, I would ask the commission members to please declare if you have any financial conflicts of interest. Seeing none, all right. Before I turn it over to Erik Olson for the staff report, I want to remind the commission, or perhaps expand, this is a legislative decision which is discretionary, but it must comply with applicable comprehensive plan provisions and statewide goals and guidelines and regulations. So there's really two aspects of this decision to the commission. The first question is, does it comply with the applicable state legal requirements, the applicable criteria, the state statutes, state regulations, and comprehensive plan?
You need a new speaker.
It is. You'll make a staff report addresses that, and you can make a finding of whether or not it complies with the requirements. If there's parts of it that do not comply, then you'll need to make a finding what doesn't comply. We'll have to decide then how to go forward on that, whether that's a severable part or whether that needs to be modified so that it does comply. Usually that's the case, the second one. However, as I indicated, there's also a discretionary aspect of this legislative proposal. That is, usually with the comprehensive plan, there's a range of policy choices that the Planning Commission and City Council can make. The Planning Commission may have one policy recommendation, City Council may have another. So the City Council needs your policy recommendation as well, and you would state why you would agree with the proposal in full, or at least parts of the proposal, and why you would disagree with other parts of the proposal. So we would separate out those policy recommendations. Then the City Council has your recommendation on the policies, the reasons why you are choosing, why you're going towards one policy as opposed to another, and then the council can then, of course, make its own decisions. So I hope that explains what the goal is tonight in conducting the testimony and hearing a report.
Thank you. So what I think I hear you saying is we can move along until someone disapproves of a certain section, and then we can take a straw vote on that section to see if that policy is objectionable to more than one person.
Right. I mean, the minutes, ultimately you'll be it's just there is an application before you. It is a recommendation to the City Council whether to approve or reject the application. It's a recommendation, okay? The minutes will reflect each commissioner's position with respect to those, and of course, ultimately, the commission will move it forward with a do pass or a don't pass recommendation. But recognizing that the minutes will reflect that some commissioners may have some, just as people do, some policy preferences on one section, and another commissioner may have a policy preference on the other. So the city council would take into account what the minutes reflect as far as the position of the parties. So,
Should we wait until we've done the full review with Mr. Olson, or do it as we go along?
well, this is a public hearing, so Mr. Olson will open up the subject. We'll talk about the criteria. We'll respond to issues that interested parties have brought up already to highlight those issues. You'll take public testimony. Then you can conduct a deliberation, and you can conduct that in whatever manner the chair wants to do so. Typically, of course, the commissioners would sort of call out what sections they want to talk about. If they don't call out any sections, then it would be in accord with the staff report.
Thank you.
All right, I'm ready to start with the proposal whenever you are, Iris. All right, good evening, Chair Leak and Commissioners. I'm here to talk about the city's proposal related to ministerial development, specifically residential ministerial development, and introducing new requirements for mitigation and public improvements to accompany some of the recent mental housing work we've been working on. So I will state we originally issued a staff report on this on September 1st with a set of recommended code amendments. Since that time, staff has received 4 emails or letters of comment. Those are summarized in a more recent supplemental staff memo that was distributed last Friday on October 7th. That should respond to and sort of include all the testimony received and outline some proposed changes that we have made in response to one of the comments in particular. So that should be the most updated version of the draft code amendments, that October 7th, 2022 piece. So with that, I will get into some of the details. My clicker needs to wake up, I think. Hey, Iris, is there? Okay. All right, I've got the right clicker now. Apologies for the delay. So just a little bit of an overview of what I'll be covering tonight. I will briefly give some background, sort of a review of what we've discussed previously at the Planning Commission back in July. I will go into a bit more detail on the proposed code amendments, covering various different sections of the code that we propose to update. And we'll finish with just some next steps, but really focus mostly on the specifics of the code today. So I wanted to point out some of the reasons why we're here today, and part of the reason why we've proposed these ministerial mitigation requirements. As we've discussed previously, one of those reasons is to comply with state requirements that require basically all standards and criteria applicable to housing, that those be clear and objective. So we actually have 2 tracks available within our code currently. Applicants are given the option of either taking that clear and objective track, or they can decide to take that discretionary review track in some circumstances as well. So another sort of update on information I'm sure you're all very aware of, but earlier this year, the city passed code amendments to allow middle housing pursuant to state requirements under House Bill 2001. So this means that middle housing, such as duplexes, triplexes, quadplexes, townhouses, and cottage clusters, is now permitted in residential areas throughout the city in zones where it was not previously permitted, largely zones that were previously single-family detached residential zones. So as you're aware, this is now adopted from City Council in July, and middle housing is now allowed under the same process that we used to allow single-family or detached single-family housing to be developed under, which is a ministerial development process. When we went through and made these proposals related to middle housing for the code amendments, we did not include changes that would allow the city to require mitigation for ministerial development. So we had identified at that time that we would need to look into this further and establish a process so that we could do that, so that we could require that these middle housing developments provide the infrastructure that would be necessary to basically serve the development. So we actually, as I pointed out previously, went to the Planning Commission shortly after the adoption of the Middle Housing Code amendments in late July and discussed this, and were directed to draft code amendments to bring to a public hearing today. So I'll just review a bit of what ministerial development means. So essentially this includes exterior modifications and the construction of new single-family dwellings, duplexes, accessory dwelling units or ADUs, and other accessory structures. And as I just explained, this now includes middle housing types such as triplexes, quadplexes, and cottage clusters. So some of the requirements related to ministerial development or just the process does not require a pre-application conference, neighborhood meeting, public notice, or public hearing. So it's a more streamlined process. It's more of a staff level review for completeness, a building permit application. So it's reviewed fairly in depth by the building and engineering departments, but also has review from the planning, fire departments, other sort of related divisions within the city to ensure compliance. And planning department specifically looks at that for zoning compliance. And the decision-making authority for those ministerial development requests is delegated to the city manager, which is a term that is defined to mean staff as well. We also have a process that we refer to as a minor development process. We use this for most of our land use approvals that would go to the Development Review Commission, for instance. So these include variances, partitions, subdivisions, lot line adjustments that would increase density, historic review, changes of use, multifamily residential development that isn't middle housing, commercial development, industrial development, and development in some overlay districts would all have to go through this process. So this is more discretionary level of review. It requires public notice. Oftentimes, most of these do require a pre-application conference, neighborhood meeting, and public hearing. So these are subject to appeal at DRC or City Council. And as I might have alluded to already, we used to process what we would now process as ministerial. These middle housing developments of 3 units or more used to be processed under this minor development review process. So the existing mitigation process that we have without these code amendments would not provide the city with the opportunity to require mitigation or public improvements to offset the impacts of ministerial development, residential development in particular. So all development, whether it's ministerial, minor, or major, just to be clear about this, would continue to be subject to SDCs or systems development charges and other fees that are designed to recompense for the development. So that's collected at the time of the building permit being issued, even for minor development, and it's applied fairly uniformly. But we would point out that those don't necessarily address the site-specific infrastructure impacts of a proposed development in the context of its surroundings in the way that we are proposing to implement. So the way that we were able to do that for minor development decisions is through the issuance of conditions of approval. We have a code section that authorizes us to impose those on minor and major development. This is a fairly, it's a fairly legal exercise, if you will, that needs to determine that the conditions for approval of a particular proposal would have to be reasonably related to either alleviating the need for public services or facilities. So that refers to all the different types of infrastructure, including even parks and open space, or eliminating or mitigating a negative impact on the built environment when those impacts are essentially created by a proposal. So again, this is kind of tied to this legal principle, really thinking of whether the proposed improvements that we would require would be roughly proportional and have a nexus to what's being proposed. So these are, again, kind of legal principles that were established through precedent cases involving Nolan versus the California Coastal Commission and Dolan versus City of Tigard, which are fairly big legal precedents when it comes to this realm of land use law. So as I just pointed out, we were directed earlier this year essentially to find a way to apply the city's conditioning authority essentially for this ministerial development through a more clear and objective process. Part of the benefit of this is to ensure that any impacts of the proposal related to middle housing are mitigated sufficiently in context of the site. It would allow public improvements to be more right-sized to their area, and of course help us further our compliance with state requirements for clear and objective housing. So I will get into the details of the proposal. I can pause just if there are any more general questions, but this is going to be a little bit more detail that I'll get into. But are there any questions so far? All right, I'll continue. So the proposal that we put forward, we've drafted proposed code amendments to establish this process, as I mentioned before, and we've essentially included those both in that 9/1 or September 1st dated version, as well as an updated version that we just released last week. So one of the major moves here, and I guess I would encourage you to, this is going to be a relatively dry presentation, but I will be going through the code amendments. So if you do have those handy, that might be helpful, but I'll try to cover it regardless. So essentially, the first.
What page would we be looking at?
We're starting on page 1 of the proposed code amendments.
Okay.
So those 1 of 25 for attachment 2 to ordinance 2908 dated 10/7/2022.
Got it. Thank you.
All right, so the first item we propose is to essentially add some terminology. So to mention streets, sidewalks, pathways, and other public infrastructure in the title of the utilities section, just to essentially reflect that we've expanded the scope of the section a bit and reorganized and relocated things for ease of use of the code. So really this is just to reflect that this section now covers these streets, sidewalks, pathways, et cetera, and that those aren't considered utilities as they're defined in the code. So we thought that was necessary to include. We also went through, in order to apply this, had to amend the applicability section to essentially apply to new dwelling units or increased density, or when the owner elects to connect to utilities. So, I just point out that we would continue not to require mitigation for detached single-family dwellings, accessory dwelling units, or new duplexes, which is longstanding city practice. Really, the idea is that those levels of density were accommodated and planned for when the lot was originally created, so that our original infrastructure planning would be able to account for that in a large scale sense. I'd just point out that these standards wouldn't necessarily apply to non-residential development. That would be through the typical conditioning process, though we do have some minor sort of changes that would change some references, I guess, to those sections here. But for the most part, this is just talking about residential development. One thing that I really want to point out, this is the biggest change that we've proposed in response to some comments that we've received. I guess in early October, I forget the exact date, it was on October 3rd, we received an email with comment from DLCD, essentially outlining that we had run afoul of some of the requirements of Division 46 in our original proposal. So that September 1st proposal does not include this provision, but because of this comment we received from DLCD, we clarified within the revised version of the amendments that mitigation is not required for any middle housing created through the addition to or conversion of a detached single-family dwelling. So specifically, we had proposed to apply this to triplexes, quadplexes, cottage clusters if created through conversions. So we had to go through and ensure that that was not something that we were including in the code amendments, again, because this was something DLCD had let us know was not compliant with state rules. So I can expand on that if you'd like, but yeah.
No question. So someone has a large house and they make it into a triplex. They don't have to have a larger water line or sewer line or anything, or they don't have, they can't be made to do that because it's an existing structure.
Well, there's one section,
You really need to get a different speaker.
there's one section that applies to connection of utilities, and that applies to any structure as it does today. If they need to get a bigger water line in order to provide service, that's, they'll have to do it, otherwise they won't have service. They won't have the right draw. So that plumbing code requirement applies regardless of the type of dwelling, commercial, residential, whatever. The purpose of this amendment is to deal with the impacts to public infrastructure that is felt by others,
Okay.
if you will.
Right.
So it's
Streets,
streets, sidewalks,
parks.
pathways. Parks, no, that's kind of the SDC.
Part of the SDC.
Take care, but direct impacts from the site.
But what it's saying is if it's already an existing structure made into a triplex, there is no additional onus for the owner to improve the sidewalk or the streets or curbs.
That's right. That would be against the law.
Thank you. Commissioner Mitchell?
Yes, I have a question on the state rule. I think it's Division 6 OAR 660, and I know that in the DLCD's letter, they cite that section, and I was wondering, is there a definition of the word conversion as used in the state rules?
The definition is just as outlined repeatedly. It's sort of middle housing created through the addition to or conversion of detached single-family dwellings. So they don't actually define quote-unquote conversion in the Division 46 rules, but they use that phrase and terminology repeatedly.
Okay. And I think, so the proposal that we have here is we define conversion in our proposed amendments and basically saying if there's a demo, then there's no conversion, essentially.
Right.
Can you give an example? What I'm just trying to understand is how the state intended to use the word conversion, and I tried to look for legislative history there and I couldn't find any. Just wondering, they use the word addition to or conversion, so I'm trying to understand where they're coming from conversion to understand whether our definition that we propose to put in there may be in conflict with what they intended.
Okay. So what is the specific question that you have?
Is a practical example of a conversion of a single-family detached dwelling to a cottage cluster or a fourplex or a triplex?
Well, it couldn't be, it would be part of a cottage cluster. If it was converted, you can use an existing structure to be part of a cottage cluster development or cluster. When it comes to conversions, so conversion specifically of an existing detached single-family dwelling, so you can picture any number of those within the community. So if an individual were to be able to provide the requisite fire separation, entry, and egress, meet those requirements for each unit, if they're able to modify their structure in order to have additional dwelling units without necessarily demolishing that structure, then they would consider that to be a conversion, more or less. So that's something that they don't really expand upon. We looked into a lot of the rulemaking, and there was a lot of it. There was a lot of process related to this, but there was a general sense that there was a need to incentivize the development or of these conversions, that they wouldn't be very likely. And so if we wouldn't provide them with the same exception that we would to single-family development, then they were concerned that they wouldn't be developed. So I think this was intended essentially to just make it to I guess reduce one of the barriers that could exist for folks that were doing these conversions. Again, it's more, it's not necessarily something that large developers do too often. It's something that I think DLCD had envisioned would be more private property owners or individual homeowners would want to do to their own properties. And you can imagine that the more units you include in your development, the more difficult it gets, the more sort of challenging it would become. The economies of scale may or may not start to make sense after you have 3 kitchens, however many bathrooms, and your former detached single-family home with 1 unit. So, I think they were just looking at the sort of economic calculus there and trying to tip the scales a bit.
Thank you.
And let me know if there are other questions about, I guess, the specific sort of way we've defined conversion or any other things to note.
Commissioner Rigby has a question.
Are you able to hear me?
I can hear you.
Oh, okay, great. So would the effect of that be really that if one is changing a single family home into a duplex, then that is exempt, but a duplex to a triplex would not, or a triplex to a quadplex, that sort of thing?
That is correct. I would expand upon that to say that even a single-family detached converted into a triplex or quadplex would also not be subject to these requirements.
Mm-hmm. And I also, I think this kind of ties into the last question, but we have recently defined demolition in a very specific way. Do you or Mr. Boone think that that definition could be in conflict with what the LCD would consider to constitute a conversion? As here, if the house is considered demolished, then it will not be considered a conversion, correct?
That's right. Yeah, we understand that to be consistent. I can let Evan Boone speak for himself. I'm Deputy Pro Tem City Attorney Boone.
Luckily, Eric, it followed the rulemaking more closely than I, and reviewed all the reports. But the DLCD language is addition to or conversion of. Now, I personally think conversion in the common understanding is you have a shell and with 1 dwelling unit, and you change it into 3 dwelling units. Same shell, same building. You have converted it from single to tri-dwelling building. Addition to means you're adding on to the building a little bit. So you can add on to it, but you still got the original shell. So the question is how much has to be left of that original shell to be an addition to the building and not a demolition of it. Since DLCD doesn't have any bright lines on it, and I think we have defined ours, and I don't see it to be in conflict with it since they haven't defined their bright lines. If they wanted to say replacement of, that somebody could replace a single family with a triplex, and that could not have a mitigation taken from it, they would have said that. So it's some lesser thing than replacement, and I think the definition of demolition is a reasonable one that's not contradicted in the rules.
I see. So it's somewhat gray, but justifiable.
I'd say we have a range of responses that would be compliant, and there is some deference to different sort of city rules and regulations within Division 46. So yeah, I think there's no bright line by design, perhaps.
And if DLCD wants to amend its rules in order to define it, we'll deal with that then. But that's what they're going to have to do.
All right, and I'm glad we were able to have that conversation, but I'll keep moving forward. All right, so we added other language. Some of this will be more routine and more just about code reorganization and reworking. Other sort of components here will be more substantive. So I'll try to focus more on those. Essentially, this section is referring to item C and D. Item C involves a proposal to essentially just relocate some of the language related to the dedication of easements and remove some other language to ensure that it's not subjective and that it can be considered clear and objective. Item D essentially involves us moving a lot of the different code sections related to which plans and specifications will be provided by the city in terms of the design of these different types of public improvements. So when they do exist, applicants are required to use those specifications that would be provided by the city. We've also relocated other language related to the rules of the Public Utility Commissioner here, and added references to neighborhood plans and design references or design requirements from the code here as well. So really just trying to button things up, I suppose, and make sure that we have all things in the right place, more or less. We added a new section on sanitary sewer systems, again, to sort of collect all the different provisions of code that had been elsewhere in this section in one place. So we're really just trying to clearly specify which design and specifications would be required for improvements to a sanitary sewer system. So they may need to be upsized if they're inadequate, when that would be needed to establish an adequate flow. If that development does not abut an existing main, applicants would be required to extend to one, so that could require some extension of sanitary sewer lines. So this is included, this is outlined in this section. Sanitary sewer lines could also be required to be extended to the upstream property line in some cases, again, sort of depending on the context. And sort of other sections of the code are again relocated here for user friendliness. Another just update from the more recent version of the code amendments, we removed the term desirable based on some input from the State Department of Land Conservation and Development. Again, just to ensure that we're meeting that clear and objective requirement.
I can just add that the extension to the upstream boundary is current code. It's just relocated. So.
Right, I think it's worth pointing out that this is all basically current code. I mean, this is just our established practice that we would use for conditions of approval that we're trying to establish sort of a new process for. So we're not proposing to really change, for the most part, any of the infrastructure requirements or different infrastructure planning documents. All right, so we've added another water system section.
Can I just put in context? That's a great. Our current code says that if you have a minor development or a major development, we'll apply the conditions of authority, which have no real standards to them. Okay, so we start from the ground zero, and we say build this in order to mitigate. The proposed code, in my way of thinking, simply is because because it needs to be clear and objective. We start from the requirement that you put in all the infrastructure, okay, that's required by all the plans. However, you can reduce those by showing, or by the city engineer finding, that that's not required. It exceeds the impact of the development. So it's just flipping it on its head from zero building up to all reducing down.
And also outlining, the clear and objective, sort of in a more clear and objective way, what the requirements or different sort of documents that we'll be referencing are. So trying to make it, again, more clear.
Would I be accurate that the Land Conservation Board has gone through all these changes and weighed in on them and only found one that they had issue with?
Yeah, they had a few issues, but I'll point those out.
Okay.
So yeah, I think that's just a good way to phrase it. I appreciate your input, City Attorney Pro Tem Boone. All right, so moving forward, as I mentioned previously, we've sort of distinguished between utilities and the street, sidewalks, pathways, and other street infrastructure. So part of our proposal here in item G would be to, essentially create a new subsection for that type of infrastructure and clearly, again, specify which designs and specifications would need to be used. So those are triggered earlier in the applicability section that I discussed previously. And the requirement could, essentially involve constructing a sidewalk in different areas depending on the plans for that particular section of or segment of road. So, essentially we've stipulated that these are required to be installed pursuant to the city's plans. Essentially, we had originally stated just city plans, but in order to further our clear and objective compliance, we have proposed to specify specifically city public facility master plans to attempt to be as clear and objective as we can. So, essentially that would really refer to a wide variety of different conditions that are covered in like the transportation systems plan and the different sort of contexts that could dictate that, whether it be the classification of the street, whether it's considered in the rural fringe of the city, and other sort of context around that development if there's existing sidewalks or curbs and gutters, essentially. So this could, require that a developer construct a sidewalk or pathway across the street from the site's frontage in some cases, if that's something that that the relevant infrastructure planning document would require. So it really is very context dependent, and we have to look at this on a case-by-case basis to determine what would be required. So it's not a formula so much, it's still looking at this in context. We added another subsection on this, essentially further down in the document, item J, again, just because these are a bit separate from utilities. So we wanted to clarify a few additional things and sort of separate the requirements from utilities. So we are clarifying in this additional section in item J that all street public infrastructure is to be contained within the street right-of-way width. We're essentially referencing an existing policy for the rural fringe that would direct different widths or components for street design in areas in this, urbanizing rural fringe, as it's called, which really, if you look at the map that's included in the code amendments, you can see that that includes areas that were defined, I think back in 2005 by an engineering policy. So there's different neighborhoods, including Lake Forest, Forest Highlands, Rosewood, Childs, and the Stafford-Tualatin CPO area. Not that that's really within our jurisdiction. But those are what was outlined as this rural fringe previously, so we're proposing to be consistent with that policy. So as I was referencing before, essentially, depending on the context, we could require that the streets would be paved, essentially, from the continuation of the roadway center line out to the applicable stated distance as provided in the relevant plans and specifications, so the TSP, more or less. And, the section also designates which jurisdiction's road width requirement is appropriate. So when we talk about the amount of pavement that would need to be required in a particular setting, we wanted to be a little bit more specific. So, and of course, point out when we're not the appropriate jurisdiction. So just to talk a little bit more about what this looks like, in a more urbanized areas, we would require things like curbs and gutters if they don't already exist. We would ask that the development pave unpaved or partially unpaved roads, that they provide public utility easements. Again, this is for new triplexes, quadplexes, and cottage clusters, more or less. Sidewalks and pathways could be required if it's, depending on the context, again, if that's called for in the plans. And of course, water, sanitary, sewer, and storm drainage infrastructure. And this looks a little bit at what it's like in a more rural fringe area, if you will, where we would ask for something like a pathway instead of a sidewalk, and a drainage swale instead of a curb and a gutter, and have gravel shoulders, and sort of more keeping with the rural character of certain areas of the city. And that was the idea. Which is, a priority for some folks in certain areas. They do value that characteristic of their neighborhood, we found.
Do we have a map of where urban fringe areas are? I think there's a map in there.
Yes, there is a map. I pointed out, I mentioned the neighborhood associations where that was meant to apply, but the map makes it more clear. It might be a little small in this printout that I have here, at least, but I would just reiterate that it would include Forest Highlands, Lake Forest, Rosewood, Childs, and then also the Stafford Tualatin CPO, I guess, in the policy is included. So just getting into what the specific requirements from the TSP could look like when it comes to street improvements, I'm including the table here on the slide from the TSP, the Transportation Systems Plan, that kind of points out the different widths of right-of-way, the different widths of travel lanes, the different types of road and street public infrastructure we would require depending on the street designation, depending on a number of other circumstances. Is there parking on both sides, just on one side? Is there no parking? Are there bike lanes, et cetera? So these are all things we take into account. So we also added an additional public infrastructure and utilities required section as essentially a backstop to ensure we're not leaving anything out here. We're also we're modifying rather the utilities required subsection to make sure that we can trigger the standards related to utilities, as Evan Boone mentioned prior, whenever there's a utility connection. So we're sort of separating this from the streets and road infrastructure requirements so that we can apply this to any situation where there's a utility connection, more or less. So this would involve the required undergrounding of utilities and service facilities like TV cable. There would be sort of different widths of easements that could potentially need to be established by utility companies as opposed to the city. So we just specify that in this section. And again, kind of move things around just to make it more clear and ensure that the relevant code sections are in one place. All right, and again, as Evan had alluded to, we do have different remedies potentially for circumstances where an applicant might consider the requirements for public improvements to be more than they would consider to be roughly proportional to the development. So we do have this first remedy, which we've called the city engineer reduction or elimination, which is essentially meant to provide an opportunity for the city engineer to reduce the requirement for what should be or what needs to be required provided for the development under certain circumstances. So when there's existing infrastructure there that meets the standards, if it's not the right time to be constructing the improvement, or if it's sort of exceeding that legally permissible rough proportionality threshold, there is an avenue within the code for the city engineer to be able to step in and make a reduction to that requirement. So really this is supposed to be the sort of first stage of the development that would, or of the potential sort of, remedy to the public requirements. So if people, thought, this is a little onerous, this would allow a brief conversation with the city engineer based on one of those requirements to allow the city engineer to essentially allow for a reduction without having to go through a minor development process, which is the next level of remedy. So this would more or less just provide an option where it's very clear to engineering staff that, it's not, that they wouldn't necessarily concur that the proposed requirement is supported by the nature or extent of the development. So if it's something that we agree with and that we think meets one of those criteria, the city engineer would be able to institute a reduction of the requirement. So that's the idea here. Again, it's kind of the concept is that this would be the sort of first option. So if folks did think that the requirement was to, either not proportional or just not appropriate for whatever reason, this would be the first of two different sort of pathways they could go down. And this is the second pathway. So this is the minor development process and what we call the mitigation limitation process. So that is a part of this code amendment package as well to establish a new limitation to the requirement to design and install required utilities, streets, sidewalks, pathways, and other public infrastructure. Essentially, again, to establish a more formal process through a minor development where applicants can request a hearing, again, through that specific minor development process that challenges the city's determination of what the public improvements should be for a particular development, what is required for a particular development. So we've gone through different sections of the code, established this new process, We've included it in the list of what we would consider to be a minor development. And again, this is kind of a two-step process to hopefully whittle away at what may or may not become, or may or may not be in certain instances over what should be required for a particular development based on that rough proportionality concept, if you will. So it's a bit, it's getting a bit into the legal details here. So I'm not sure, Evan Boone, if you wanted to add any comments to this. I think again, this gets back to the main concept that we're really going for is, mitigation really will be required to meet the full level of what's planned for in our infrastructure planning documents, unless it's not appropriate for one of those reasons as listed in this slide, or for other reasons that we could hopefully identify through this minor development or public hearing process.
Is that clear and objective?
Well, we are, the statute and the Constitution differ. The statute requires clear and objective. The Constitution requires rough proportionality, not clear and objective. In fact, the case law says it doesn't have to be with mathematical precision. Okay? So in order to meet both, clear, mathematical precision, but not mathematical precision, you require all. That is clear and objective. The statute allows, the state statute, clear and objective, allows subsection 6 says that there can be an alternative process for discretionary, much like we have setbacks, but we also have variances. So you're required to comply unless you want to apply for a variance. Okay? So the rough proportionality option here is available to the applicant. They don't have to use it. They can install the exactions clearly and objectively to meet the requirements. But if they think that there is, that those exactions would be in excess of the rough proportionality per the Constitution, then they would do this. Lincoln City has been using this process, having the applicant file a rough proportionality analysis for, I'm going to say about 8 years. So it's gone up to LUBA. It's been tested, I think, in two LUBA cases. So I don't have any great problem, and I don't have any great concern there. We did add, as Erik mentioned, we did add the city engineer sort of off-ramp in order to avoid, because really, if you look at it, I mean, you'd say, impose all the requirements clearly and objectively, and then if the applicant wants to, like a variance, let them apply. Okay. But that didn't make sense where we would agree that that's too much, as we do now, okay, under the conditioning authority where it reasonably affects, then that's what we apply, is to the extent it reasonably is affected by the development. So that sort of off-ramp, I don't think an applicant is going to challenge the city engineer's exercise of that opportunity unless they say, no, I think it should be more, okay? And then we have this provision for the more.
Thank you.
I think there's a corollary in the existing tracks for housing that we have in the code right now. There's a clear and objective track, and there's a more discretionary track. So obviously, the initial, option for mitigation requirements is fairly clear and objective. There are a lot of documents we reference. We make that very specific. If there is a desire, though, we do have the opportunity to talk about, it in a more discretionary track, if you will, through a minor development.
Do we see that very often?
Do we see what very often?
Evan's saying yes. That they asked to roll back from the higher standard.
Well, we currently, prior to the middle housing being effective, anything triplexes and above were minor developments. We had a clear and objective track for those, okay? But then we also had the building design standard you could apply for. And I think it's fairly well applied. I mean, they applied for building design review just as much as they did for a clear and objective on it. They want the house to look a certain way, or they want the multifamily dwelling to look a certain way. So, ask for that review.
right, and I'll go ahead and just finish up with this presentation. There are a few other items I just want to mention before concluding my presentation.
Wait just a moment. Commissioner Phillips, did you have a,
Yes, of course.
I didn't see it on my thing here.
I had the light on, sorry.
Lights are on, but no one's home on my
Okay,
little
so it
list.
doesn't matter. So I'm having trouble, could you go back to that one? Okay, there it is, okay. I'm having trouble understanding why a homeowner or somebody building something would want less than the city. Could you give me an example? I mean, utilities, streets and sidewalks? I mean, can you give me an example of why? It's not so much what, it's why would they want it? What's the rationale for not wanting public infrastructure that you're ready to build for them?
No, they're not going to build it. They're going to have to pay for it
Right,
themselves.
this is the
That's why they-
homeowner, well, excuse me, the developer, that can be an individual as well as a company, all right? They're going to develop, in this case, multi-dwellings. So the city says, if you're going to develop multi-dwellings, you need to reduce the impact on the public infrastructure, the street system, the sidewalks, in order to keep the traffic flowing as if your house wasn't there. Okay, so you have to mitigate the impacts of your development. We've had, I think an easiest example would be, we require sidewalks in front of the development, okay? Pave in your sidewalk, right? If you have a corner house, and let's make it 100 by 100, okay, rather than 50 by 50, but 100 by 100, we've had situations where that. So you have 200 linear feet of sidewalk being required, along with a dedication for that land, okay, to put it in, and you have one house going in, let's say. Well, you might say that exceeds the rough proportionality impacts of 2.5 people in a house, okay? So I want to put in less sidewalk, you know. And so we've looked at those and said, yes, that you only have to put in one side of it, because you're right, it does exceed that. Okay, for that.
Yeah, happy to answer the question. Sorry, we didn't note that earlier. All right, so I'll keep going through. If there are no questions, I guess right now, if there are no further questions, I'll keep moving. So we've also proposed essentially to amend the improvements in security subsection of the review procedures in our code, essentially to reflect that these are now going to be more direct standards and not going to be instituted as a condition. So just kind of update to the language there, and added some language to the review criteria for ministerial development section, essentially to be able to require utility and public infrastructure mitigations for ministerial development. Again, just kind of really cross-referencing different sections, referencing back to that original 1B and 1C that would sort of be the applicability section here. So we've also amended the additional submittal requirements, essentially just to make sure that we receive sufficient and legible information on the public improvements that are being provided by the applicants for development or construction. So what kind of scale do they need to use? Just kind of language that requires it to be legible and just makes it clear that we need to include various different elements such as curbs, gutters, swales in the actual drawings that are submitted. So just kind of, again, collecting those requirements in one place to make sure that they are easily understood by applicants and that they don't have to sort of jump around the code too much to find it.
I would just add, engineering considers this a cleanup. They already do this rather than having a scale of 1 to 100. It's scalable. As long as it's scalable, they're fine with it. So that's not a policy issue. That's just administrative cleanup.
All right, and that concludes my discussion of the proposed code amendments. I'll just end my presentation by pointing out that obviously we're having a hearing today at the Planning Commission. We do have a City Council study session on this topic scheduled for later this month, next week, October 18th. And we also have a tentative date for the City Council public hearing, depending on whether this is adopted or if this is approved by or recommended rather by the Planning Commission. So we do have a tentative date for a city council public hearing for November 15th.
So what I think I hear you saying is we need to move forward in discussing this and either saying yay or nay to move it forward to the council, correct?
That's correct. That would be the next step if you did recommend doing so.
Thank you. Do we have any discussion on any of the items that you find objectionable or that we haven't already discussed for clarification?
Commissioner Rigby has a question.
Thank you again. Commissioner Rigby?
Just to test again, are you able to hear me?
Yes.
Okay. If I may ask staff about returning to the applicability section. Looking at, so it says all development that, and then we have a couple examples where it says, requires or connection, for example, or connection to utilities is elected, or or street/sidewalk or other public infrastructure is elected. Would that be construed to mean that, say, if a homeowner elected to connect to the gas line, that just by virtue of doing that, he would be required to undergo this kind of analysis and do some sort of mitigation, or would that not be considered development in and of itself?
Thank you, Commissioner Rigby. So the proposal would essentially, apply, or the mitigation requirements would essentially apply if it was elected that a connection to utilities, was elected, or if there was a connection to streets, pathways, et cetera, other public infrastructure is elected. So that would be essentially just requiring that if there is a proposal to provide that infrastructure where it may not be required otherwise, that they construct it pursuant to applicable city plans. So it wouldn't necessarily apply the same way, in terms of the street requirements if there was an election to connect to utilities. And that's part of why we've separated those different things, to ensure that, if you're going to want to connect to city utilities, that you don't, and you're not really increasing density, that you aren't necessarily required to provide a sidewalk or something of that nature, because they're, again, separated within this proposal and distinguished as different types of infrastructure.
It looks like Mr. Siegel would like to make a note.
Well, thank you, Commissioner Rigby and Chair Leak. I just wanted to add on to what Erik said, that there are public utilities and private utilities. Private utilities are natural gas, power, telecommunications, cable, and so on. Public utilities or city utilities are water, sewer, storm drainage facilities. And so I think, correct me if I'm wrong, Erik, but the ordinance, it invokes the public facilities master plans and the requirements, the standards therein, but not, it doesn't trigger anything, or nothing would be triggered by a private utility extension. Someone's trying to connect a cable, it's not a demand on public services.
That's correct. That wouldn't be a connection to city utilities. So.
Thank you.
Okay. I mean, I will note that there is some ambiguity and some agrammaticality in there. One would have to read it like all development that connection to utilities is elected. So I think it's unclear what exactly the meaning that is. I would recommend that it be reviewed for grammaticality there.
The standard has to apply if the applicability standard is, does the standard apply? It has to apply if an applicant wants to bring in some additional utility, public utility. They elect to do so. They're not doing anything else. They want to bring in another another gas line, they want to bring in another, well, another water line. They have to design that water line in accordance with our specifications. So we have to pick it up for that. Sometimes, of course, the plumbing code requires that. They don't elect it, they require it. So that's also to pick up that, to design the infrastructure, whether it's if elected or whether it's required by other code. Okay? And then when you're dealing with streets and sidewalks, which is really the big issue here, of course, they never elect, I mean, you don't elect to do streets and sidewalks. That's required, and that's required by the plans, the city's public infrastructure, public facility master plans. So.
I see the utility of having the section, but in the wording, it's not actually saying anything. You know, it would have to be read, all development that connection to utilities is elected.
Can you tell us what page you're on?
I'm looking at the supplement on the first page of the proposed code changes. It's under section 1, applicability. I'm specifically reading from that section 1 and continuing into section 1A.
Of the 1B?
And I believe that section 1B is similarly flawed.
Do you have a page number?
In the PDF, it's page 5.
It's page 1 of 25 on the
I see, okay, thank you.
code amendments.
Got it. Thank you.
So perhaps something like all development that includes elective connection to utilities. Just a note.
The applicability has to be a broad scoop, so that whether they elect to do it or whether they are required to do it, it makes the standard applicable.
I'm good
Then,
with that.
once the standard is applicable, you then look to what do they have to do as a result of the applicability? And that's where we get into what is the technical standards for construction, and then for streets and sidewalks, I mean, what is the impacts?
Right.
You have to design according to the public facility master plans, including streets, transportation, to the extent
Right.
it's reasonably related to the development.
Well, I hear Commissioner Rigby's input. I think the way it's written is acceptable to me. Anyone else have a different opinion? If not, we'll leave it be.
If we find grammatical errors, we'll correct them in the final document. I think that's your point. Commissioner Rigby will look for that.
Thank you.
So at this point, do we want to make a motion to accept these changes, or do we have more discussion? Yes, we could certainly do that. Do we have anybody who would like to participate in the discussion from the public? Iris is indicating no. There were several letters that were sent. I hope we all got a chance to read those. Anything further that anyone would like to add or discuss?
Sorry.
Go ahead.
I'm looking at the letters, and two of them specifically talk about parking, okay, which seems to be always related to anything associated with housing. So I guess my first question is, one, as Mr. Ross talks about, if you're going to build a duplex or, take a single family, they go to duplex, triplex, whatever, there'll be some parking on the new, if you got one car parking for the house and now you got three houses, I'm assuming you got three parking. The parking code, I think, is the answer, is what you're going to give me, right? They're going to apply the parking code appropriately.
So our proposal doesn't involve any changes to the parking requirements, so that's not really applicable to the criteria here. But I would say our code does require that all developments provide one space per dwelling unit of middle housing, at least one space per dwelling unit on site. That's our existing requirement that was approved back in July. Well, it's always required that it be provided on site, but it's applicable to middle housing as of July.
Right, so the public parking code will answer Mr. Ross. He said, I just want some parking on site, so that should be answered with the code. The second question I got, though, is Ms. Karnak. I'm not even sure I understand what she's saying. It sounds like she's saying she wants the public, now that you've got this new coding for these new developments, she'd like some of that infrastructure put in on her street too, even though she's not a new, is that what she's saying?
It sounds like she's supportive of if a development were to come in, that they provide infrastructure. That was my understanding. But I'm not sure if she's asking for any specific improvements on her street. And if she were, it would not be relevant to the applicable criteria. And that's not what we're proposing to do here. But yeah.
Well, as she should be, it's her street, so I'm sure she's asking for her street if she's asking for anything. But she should be doing that if she's concerned about it. But I don't think this, I think what you're saying, this is probably not the appropriate forum to be dealing with this particular kind of issue. Is that correct?
That's correct. We're not proposing any development. And so I think there might be some confusion that, we're proposing a development or something in a particular place. I will say we did receive a lot of questions and calls where I had a lot of helpful conversations with folks that didn't quite understand what this all meant based on their Measure 56 notice. So there could be, some very understandable sort of, misunderstanding of exactly what we're proposing or how it applies in a particular street. But my understanding was that she was simply supportive of the proposal to ask middle housing developments or new developments to provide sidewalks, roads, other types of infrastructure in her neighborhood if they were to come.
Thank you. Seeing no public input being brought forward and no more other questions. Oh, I'm sorry. Commissioner Mitchell.
Thanks. Sorry, I wanted to go back to the DLCD's comments because I've been grappling with them since I read them, and I know we talked about the definition of conversion and demolition, and I understand all that, but at the end of the day, what I'm trying to figure out, and their comments are not exactly like hitting the nail right on the head, they're sort of probably intentionally being a little bit vague by their comments, but are they, in your opinion, Mr. Olson, is the DLCD sort of trying to say if you have an exception for duplexes, you need to have an exception for all of them, right? Because, and they don't come right out and say that, but that seems to be the subtext of their comments.
Yeah, I think they actually reference the section of Division 46 that makes that very explicit. If there's any exception to public infrastructure, I forget exactly how it's worded, but it's essentially, if there's any exception that's to public infrastructure requirements that's provided to detached single-family dwellings, you have to apply that same exception to middle housing. So not necessarily duplexes, but you need to apply the same exception that would apply to detached single-family dwellings to all middle housing, which is a bit different than other sections of Division 46 where it's been kind of just treat duplexes and single-family, detached single-family the exact same. So that is probably why we didn't catch this the first time around, because it is a little bit different in concept to some of the other requirements. And again, this relates specifically to that infrastructure planning piece. So yeah, it is, I think, very explicit in the actual Division 46 language I found.
Okay. It's one of the other comments is this, the call out about not having an analysis on the impacts of, duplexes versus threeplexes and fourplexes. And I agree, I read, the proposed response and I agree with it. But again, that's just another issue that I'm having, which is by granting these exceptions, which frankly make sense to me. I'll tell you that they frankly make sense to me the way we're proposing it. But is the DLCD, trying to walk us back on that? And are they saying apply it to everything or apply it to nothing, right? And they don't want to come out and say it. So I guess what I'm trying to get here with my long-winded, not question is when we vote on this, commissioners, I just want to go in eyes wide open on we may be going a little bit around of what the DLCD is trying to say to go around, and I just want us to all be aware of that when we make our recommendation to the City Council.
Madam Chair, if I may try to elucidate somewhat, this is relative to their second comment, right, as I take it. And what they say, this has nothing to do with the conversion or addition, because that says, yes, you cannot allow that. All right, so second one is, it's an open question and has not been directly addressed in case law at this time as to whether you are mandated to have the same degree of exactions, of mitigation requirements on one type of dwelling as you are on other types of dwellings. They point to nothing in the Middle Housing Code. They point to no case law that says you're mandated to exact public improvements to the same degree of rough proportionality from all types. So I agree with that. There's nothing mandating it. That's a policy choice that the city can make and has made. And the city made that choice when it said we're only going to require conditions of approval for mitigation requirements to minor and major development. We didn't impose it before to ministerial. Ministerial is single-family residential, duplex, and ADUs. So we're continuing that. This does not change the city's prior policy choice to not exact those. There can be some rationales for it. I mean, the common rationale, I think, would be the lot's already created, so any exactions, any mitigations were taken at the time of the lot creation. That would apply. That would be a logical analysis if all lots created had a mitigation analysis applied at the time of creation. They did not. In 1886, when first edition was created, they didn't do that kind of analysis, I think. So, it's an imperfect science if you were to go, do that. It also doesn't apply to annexations. The lot was created outside of our jurisdiction. It comes in. Did it have its exactions? Did it have its mitigations imposed at that time or not? I don't know. But we did not, back when we created conditions of approval, which have been around since at least 1982, okay, because that's when we have basically the current modern code. That has always, conditions of approval, the requirement for public infrastructure has never been imposed. You can't impose a condition of approval on ministerial. It's a yes or no. So we have never backed it up to single-family residences that were approved through some other process that did not have a mitigation analysis done. So we're just continuing that same policy choice.
Sure.
Just a few other notes on that, I suppose. As City Attorney Pro Tem Boone had mentioned prior, there is precedent for this in Lincoln City. They've been doing something similar to what we're proposing here. We really use that as a model for what we've developed, and they've been doing that for, I think you said 8 years, with some challenges. Of course, it's not the same as what we're proposing, but it's a similar
when
concept.
I said that, I mean, they have been using a clear and objective with a rough proportionality off-ramp variance process for eight years or so, because the clear and objective requirements for housing applies to all types of housing, has been around, and that's how they've addressed it. So this, in addition to middle housing, and the fact that we're now increasing into triplexes and quadplexes now ministerial, I mean, this also addresses single-family development type thing, so you have clear and objective standards applied for single-family as well, because we're required to do that.
Thank you for that very thorough, good explanation. Do you have any further questions for them?
Not at the time. Thank you.
Thank you, good. Anyone else want to weigh in?
If I may, just to follow up on one other thing, I think, I guess I would just point out that I think that we have seen, or I've heard, I guess, from the DLCD that they've provided similar comments to a lot of other jurisdictions and pointed out in their comments that this is still being worked out by many other jurisdictions. Many other jurisdictions are sort of struggling with this. So I don't think this is a unique comment to Lake Oswego. And I think that it applies basically to anybody that's trying to enter this world of, mitigation requirements for middle housing. It's new territory. So I think that my sort of read on that was that, they may have issued similar language to other cities.
Sure, and I think that's actually the perfect way to end it, which is by having these mitigation standards in Ministerial, which now middle housing applies to, we are adding, a little bit of a burden on a developer who is going to which this is going to apply to some sort of middle housing, right? And arguably, does that go against the underlying policy of the middle housing passed by the state, right?
But I would say that we're not.
And why are we not?
Because right now, we do impose a burden on triplexes and quadplexes prior to middle housing.
But now middle housing's passed, right? So currently we're not.
Well, and as we said when we adopted the middle housing standards, that the mitigation requirements needed to catch up to the fact that we're now switching from minor development, where we had the authority to impose the conditions of approval, and we did, to now track it into the ministerial side.
Sure.
And we're just continuing the same process for single family, duplex, triplex, quadplex that we've had before the middle housing came along.
Sure.
Yeah. And I would say that there's also a very long, throughout the rulemaking process, there was a long conversation about this, back in, I guess it was 2020, we were talking about this a lot at the Planning Commission, where there was a process established for what they referred to as the infrastructure-based time extension request. And the city had some conversations as to whether we wanted to pursue this extension request. A lot of this conversation was based on that sole concept that the state had really established fairly early on in their rulemaking that, essentially the city is able to require new middle housing to provide the infrastructure. There was a lot of really, heated response to the original proposal. A lot of folks are saying this is essentially an unfunded mandate for the city to go in and update all of its infrastructure, and how are we going to do this? And DLCD was very explicit about saying, the concept here is that you can't just preclude development based on this supposed lack of services, but you can require the developer to provide that when they come in and develop. So that was a very early principle that actually influenced our decision not to apply for that infrastructure-based time extension requirement, or it was a request, but the IBTR, if you will. So we did discuss this and determine again that, our city infrastructure could likely handle the marginal impact of, new duplexes and things like that, but that we would still want to impose requirements as we were allowed to by DLCD for things of 3 units or more. So that was, again, that's something that has long been sort of a core tenet of the rulemaking. So I do feel fairly strong about DLCD providing that ability explicitly to the city to say, you can do this, and specifically, we would have made a different choice if we weren't able to do this, I think, in the past. So.
And I would just kick his dead horse once more by saying that DLCD adopted a provision that said no mitigation requirements for conversion and additions to single family. They could have said more. They did not. So.
That's actually the basis of my confusion, if we call it that, which is the use of the word conversion, right? Because what does that mean at the end of the day? Because if you're how rare is there going to be middle housing on top of a former single family house, right? Like, I imagine that's going to be very rare, if at all. Most of this is going to involve demolition and a rebuilding. So I was very interested in why they used the word, and it says or. It says addition to or conversion. Yep. So, and I don't want to beat the dead horse anymore either. Thank you.
Thank you all. Well,
Commissioner Leek,
yes.
or Chair Leek, this is Scott Siegel. I won't beat that horse, but I'll put another one up for anyone who wants to take a shot. So another dimension to this is attached versus detached forms of middle housing. And as you'll recall, our city, the Planning Commission recommended and the City Council approved middle housing only in attached forms of it, not multiple detached units on a lot. And so, you know, if you think about, and again, the state has not defined this, it's untested, it hasn't been litigated, but, you know, could in addition mean the addition of detached units on a lot with an existing single family detached house. And then you begin to see, you know, that there is an incentive there for, you know, infilling and adding middle housing where there's existing housing stock and trying to discourage the tear downs and replacement of that housing stock. So that's not the world that we're in because we're only permitting attached forms of middle housing. But, you know, I can understand the thought process from the Rules Advisory Committee. They really were trying to, you know, encourage retention or I guess additions and possibly conversions of existing housing to middle housing.
I
And
agree.
maybe, yeah, maybe not just the internal conversion of the, you know, within the shell of an existing house.
Although you
But
do
that's,
see that in places in Portland. The
oh yeah, yeah,
big old houses in Northwest that have been made into condos or
oh yeah,
offices and things like that. So Lake Oswego may not follow that path, but thank you for that comment.
yeah, thank you.
We gotten everybody? All right, then I guess what we're going to do now is see if we have an ability to move forward and propose to amend the Community Development Code sections LOC 50.06.008 utilities, LOC 50.07.003 review procedures, and LOC 50.07.004 additional submittal requirements to establish a new process to require mitigation for ministerial development through the provisions of public improvements to offset the impacts of the development on public infrastructure. Do I hear a nomination or someone who wants to bring this to a vote?
I'd like to make a motion for us to approve LU 22-0031 and direct staff, this would be a preliminary recommendation, and direct staff to come back with findings, conclusions, and order.
Do I have a second?
I'll second.
Thank you. Want to call the roll?
A discussion on the motion, Chair?
Oh, go ahead.
I would just like to say one of the concerns I had was what Commissioner Mitchell was bringing up with the DLCD comments about, you know, how we really applying or exacting, you know, requirements for single family versus triplexes or quadplexes. I think staff did a good job at explaining that, you know, we already have this process in place. And also I did read the DLCD's comments to say, hey, this is more just a warning. There's no really case history that applies specifically to middle housing. So be careful, but I think staff's done a good job at looking at this, and I'm comfortable moving ahead with it. But that was my major concern.
I agree with that totally, and I also think they had to put it on record in case they wanted to pursue their point further. They had to, you know, upfront say it. So we have a motion and we have a second.
Yeah, I'd like to make one more,
Okay.
just one more comment real quick, in agreement with what everyone is saying here so far. To me, this is, I guess, a lot more straightforward in that you're taking these middle housing types that used to be approved under a minor development process with mitigation as required, and since we're moving them to a ministerial process where mitigation is not required, there need to be something in place that helps the city to oversee the impacts of the impacts of middle housing development on the infrastructure. So I think this these amendments do that, and I think these amendments also correctly provide reduction measures when expansion of the infrastructure is not reasonably required. So that's my take.
And I would like to add that I think staff did a really good job in doing this. It's pretty technical, and it's interesting, some of the letters that were sent to the commission. I don't think the public has their arms around all this. And, and it's going to be a while before, it comes to a point where they're totally educated on it. And this is going to be a process in flux, I'm sure, for the next 10 years, so. There we are. Call the roll?
Heath,
Yes?
Leek,
Yes?
Mitchell,
Yes.
Phillips,
Yes.
Rigby,
Yes.
and Stewart.
Yes.
Tentative findings, written findings brought back on the 24th of October.
Thank you. Do we have any other business to attend to tonight? If not, then let's look at our schedule review.
Excuse me.
All right,
The findings need to come back on the 25th because we're meeting on Tuesday, not
that's a good
Monday.
point. Yeah, so we're actually meeting on Tuesday, October 25th, as opposed to Monday, October 24th that week. That's true.
Right.
News to Mr. Boone, unfortunately, but thank you for the clarification. So on the schedule upcoming for the 25th of October, not the 24th, again, that'll be a meeting date on a Tuesday. So pointing that out that's different than our regular Monday meeting date. We will be considering findings for tonight's recommendation related to the mitigation for ministerial development, as well as receiving a presentation from David Smith of the Lake Oswego Fire Department on the city's Community Emergency Response Team program. In addition, we'll be discussing goal setting for the coming 2023 Planning Commission year. So thinking about the different suggestions we've received from the Planning Commission so far and talking through those and exploring that further on the 25th. On the 14th, we will be holding a work session related to the Palisades Neighborhood Association Overlay District effort. We've been working with, or I've been working with, staff has been working with the Palisades neighborhood representatives to establish some boundaries based on common physical characteristics of the neighborhood. So that will be the focus of that discussion. In addition, so that will be essentially the only item for the 14th. I would mention, though, that we will need to hold that meeting remotely because there is a city council study session, or actually a special meeting that had to be scheduled that night and to use the council chambers on the 14th. So we are proposing to hold the Planning Commission meeting remotely, that work session. On the 28th, we have a hearing scheduled for the annual Community Development Code amendments that Johanna has been discussing with you in recent months. And on December 12th, we have a hearing scheduled for non-conforming residential development. We also will be continuing our goal-setting conversation and potentially adopting findings, or potentially continuing the hearing related to the annual code amendments, depending on the direction that goes. But that should bring us up to date for the rest of the year. One thing I will note is that we had originally planned for a House Bill 2003 work session later this year. We decided to push that out to early 2023 due to just bringing a new consultant on board and really needing to work with them to put together a schedule and propose sort of public outreach plan. That's one of the deliverables that we'll be working on with the consultant. So we wanted to bring that to the Planning Commission to discuss that after it had been sort of talked through and developed with the consultant. So anyway, we wanted to be able to discuss that sort of scope and process and schedule with you. So we'll be looking at that for early 2023.
Wonderful, thank you. Any questions or comments on the schedule?
Erik, I think we may want to check with the Assistant Fire Marshal, David Smith. I'm aware there may be a conflict. Again, we were anticipating, our normal meetings on Mondays, but I think Deputy Fire Marshal Smith is actually conducting a training class every Tuesday for like the next 7 weeks. So I'm not sure if that conflicts or if there'd be somebody else covering that class. We just may want to check on that and potentially move it to another meeting.
Right, yeah, I will follow up with David Smith.
Thank you for that comment. Want to have him here. With not seeing that there's anything else to discuss, I move to adjourn the meeting. Do I have a motion to adjourn?
I move.
Second? Second. So be it.